Hello students, my name is Liz Attia and today's topic is negligence law and informed consent. Okay, so negligence law and informed consent. So informed consent is actually, or consent rather, is an act of reason and deliberation. It requires a person to have sufficient mental capacity to make an intelligent decision, and it demonstrating consent by performing an act recommended by another. So consent assumes a physical power to act and a reflective, determined and unencumbered exertion of those powers. So it must actually be a process as a result of deliberation, of thinking, of engaging with material, of reason, based on information which is actually provided. So time is clearly one of the things that's important there, that people are given the time to actually consider and to read and to think and to find out and to engage their cognition, I guess, if you like, around the information, which is actually to cognitively engage with the material that's being provided to them to make a decision. So it's unaffected by fraud, unaffected by duress, misrepresentation, or even mistake. And those elements are considered to be important to provide consent at law. So it's very important to obtain consent where a health provider has to touch or physically examine patients, and without such consent there's a cause of action for trespass to the person. So without informed consent, the health professional leaves themselves exposed at law to an action under tort of trespass or assault or battery. And in fact, that's actually in the Crimes Act. So consent is a complete defence to an action for assault or battery at law. You might actually say, well, does consent need to be in writing? Interestingly, at law, the law actually says, well, in fact, consent need not be in writing. However, as a matter of precaution, it should be, particularly for certain interventions such as surgery. Under the Human Tissue Act, consent is required in writing to establish whether a person is legally dead, and that becomes important clearly for organ transplantation and for consent for human tissue regeneration and transplantation and donor issues. So So consent needs to be in writing for particular procedures. The principles of informed consent say that there are certain elements which need to, at law, be satisfied in order to be considered valid. The consent must be free and voluntary, so it must be given without coercion, without manipulation, without pressure. And there are a number of cases in your textbook for this week which actually go to that idea of free and voluntary consent. There's the case of the young girl who is whose mother is actually in the room, who refuses to have a blood transfusion, and the impact, I guess, of her lack of consent on her decision-making, and whether that was completely autonomous, or whether the mother was in fact influencing that decision or not. So at law, the consent must be given free and voluntary without coercion. It cannot be general in nature, and it must be limited to one specific procedure. So I guess I'd ask you at this point to consider whether in practice that has been your experience, those situations where you walk into a medical centre and they give you a form to fill in, which is purportedly to give consent to treatment, or you walk into your dentist surgery, fill in the form right at the very beginning and then never actually give consent again for the next 3 or 4 years. That's in fact at law not valid consent, because the consent must be specific to the procedure which is actually being undertaken or recommended at the time. So the consent must be understood by the patient in relation to what is about to be done. And there are, in fact, criminal cases arising out of the lack of understanding of what's being performed. So it's not enough to actually just provide the information and say, well, listen, the information was given. The health practitioner or the health practitioner has an obligation to ensure through reflective questioning or some other systems or measures that the information has in fact been understood by the patient. And that goes to the way that the health agency would ensure that their systems have a quality checking mechanism to make sure that patients are fully cognizant of what it is that they're actually consenting to. So in your protocols and in your experience in practice, there must be in that some measures to ensure and to safeguard against the claim that the patient hasn't understood the information being provided to them, whether it be translated material, having the availability of an interpreter, having information that's given away, given to people and that they come back and ask questions, reflective questioning to actually ask, well, what did you understand by that? Tell me what you heard. What do you think of this bit? And sort of testing whether people have completely understood the information which has been provided to them. Similarly, as we said, it must be specific both in terms of the procedure, but interestingly also it must be specific in terms of the health professional or the provider who's undertaking the particular intervention. So that person must be in fact nominated in the consent, and that particular person is the only person then who in fact has the consent. Sometimes you'll actually find in the paperwork it will have, you know, this doctor or any person by this agency. So health agencies will try to get around that particular element of informed consent, but it's untested as to really the law, whether the law would actually accept that as a defence. So there are some exceptions to informed consent, one which we've talked about already, which is the doctrine of necessity under an emergency, so where the client might actually be unconscious, and in those circumstances consent cannot be obtained. And remember, the consent is only implied insofar as it is to remove the emergency, the life-threatening nature of the emergency. So it's to stabilise the person's condition. It's not then to do anything and everything you actually want to the person. The lack of consent is also recognised in Section 37 of the Guardianship Act, and this is under the doctrine of implied consent. This only relates to where there's no advance directive which might have been given. So if there is an advance directive, then that is in fact what would be relied on. It's only in the case where those expressed wishes of the person before they became incapable of giving consent are considered that the Guardianship Act would actually come into play. So interestingly, consent can actually be withdrawn at any time, and the law recognises that. If there is a contract of service between the health professional or the practitioner and the client, it does raise the question as whether there would in fact be potential for a claim of damages by the health professional for breach of contract if they went to some expense in setting up or getting ready for the intervention and then the client actually changed their mind. Under no circumstances, however, would a court actually adjudicate for specific performance of the contract, because that would actually just fly against the principle of autonomy. So no court would actually order for specific performance. The best that would come out of that would be some claim for compensation for the loss that the health professional actually incurred because of that breach of contract. So you might ask the question quite reasonably, well, you know, how much information is actually necessary to meet this standard according to informed consent? If a patient has a general understanding of the proposed treatment, there can be no assault where consent to the treatment is given. But really, how much information is necessary then to avoid a breach of duty of care, because it's a separate issue again. Remember, the standard in Australia is that subjective standard. So it depends on what the court itself would adjudicate as to be the necessary information in those particular circumstances based on the Rogers and Whittaker principle of the subjective standard. So what in those particular circumstances would that client or patient need to know? So as you can see, it's quite a high standard. So a couple of lectures or so ago, I asked you to consider the elements which enable valid consent and go to both information and enacting. And in fact, here are the answers for you. So this is adapted from Kerridge for the readings for this week. So I'll draw you back to have a look at those readings for the full detail in terms of what we mean. But the elements which enable valid consent are competence and voluntary. The elements which inform, which is in relation to disclosure of information, what information is in fact provided, and also then the client's understanding of that information. And then the elements which enact consent, which demonstrate that consent has been given. So that's the decision as well as the authorisation for the intervention. Thank you, students. That brings today's topic to an end.